Lord, I beg to mention, my Lord, item 26, the hearing list. Kindly have after 2 weeks, my Lord.
Yes?
Item 26 of the hearing list, my Lord.
26.
My Lord. No objection.
Why after 2 weeks?
Lord, I have to do some research, my Lord.
You're a seasoned counsel, what research you have to do?
No, my Lord.
2 weeks at request of the counsel petitioner due to personal difficulty.
Apply, my Lord.
Please, Your Lordship. Lordship, I seek your kind permission to move an unlisted urgent matter, my Lord. An unlisted matter.
Why? What's the urgency?
Urgency, my Lord, is that Executive Magistrate in Nongpo has drawn up proceedings against me under Section 133, public nuisance. Allegation is that there is a drain which I have not maintained properly.
You're a factory?
No, my Lord. But on my property, I have my own small business, and I have about 47 tenants who run their own small petty businesses, my Lord. So allegation is that the water seeps into the neighbor's compound. I have tried to rectify it. Spot inspection was conducted day before yesterday by the magistrate in the presence of police personnel. For no rhyme or reason, my Lord, he has directed the police personnel to shut down all businesses on my property. Businesses have no connection with the seepage of water, my Lord.
Okay.
Highly pleased.
Yes.
I beg to make a mention of item 4, my Lord, of the supplementary list. This was the matter which was part heard yesterday. I was hoping, my Lord, to give some further submissions on proportionality. I'm praying if it come out on Monday, Lord, Tuesday, Lord.
Sorry, you already finished your submission.
On proportionality, my Lord.
Proportionality?
Lordship. So
See, that the court has not even fallen from what you said.
No, since, my Lord, it has fallen from the court that I have some argument with on the proportionality aspect of the punishment.
That you have an argument.
You
can make your
till Tuesday,
replies.
Lordship.
See, we already fixed it today. We thought it just
I'm
pulled it off.
praying till Tuesday, my Lord. Till Tuesday.
Well, so far as I understand, petitioner submission was closed, man.
Only
It was
with
for me to
regards to
reply.
the proportionality.
Exactly.
Only with regards to the proportionality, my Lord.
You can do your research meanwhile, and then by the time matter comes up,
Tuesday,
by the time
I sincerely pray, my Lord. Tuesday we will not
those who fight and run away live to fight another day. You believe in the dictum?
No, my Lord. On Tuesday, Lordship, we will do it.
Okay.
This up is good one. I have nothing.
Yes. Due to personal difficulty expressed by Mr. S. Deb, matter. List the matter on Tuesday.
Much obliged, Lordship.
Part heard matter.
Lordship.
Part heard.
May I please, Your Lordship, I beg to mention number 27 to let this matter take after 2 weeks.
Item number
27.
Lordship, for the respondent
you have some objection? Two weeks, yes.
Please, Your Lordship, I beg to mention item number 25, Your Lordship, and brings for 2 weeks' time for hearing.
25.
Yes, Your Lordship.
You're for the petitioner?
Yes, Your Lordship.
It's a service matter again, my Lord.
It's a police matter.
Police person, my Lord.
Police, anyway. Okay, 2 weeks, personal difficulty of the senior. Yes, Siddiqui. M.Y. Siddiqui. Oh,
Yes,
who's the
sir.
senior?
M.Y. Siddiqui, Your Lordship.
He never come to High Court.
No, Your Lordship. Sir S. Kumar used to conduct High Court cases.
Okay.
Deeply obliged, Lordship.
See, item number 20. CRP, Lordship. Item number 20, Lordship. I pray for 2 weeks' time, Lordship. Joint request, Lordship.
Which year is it?
19, Lordship.
What's the matter about?
This is closing of written statement. There was a delay of 23 days, Lordship.
Then why small matter like that? Why you want to adjourn?
You can have it next week, my Lord, on Tuesday.
Why you want to adjourn it?
Tuesday. Next week.
10 days. Oh, sorry. 20, right? Not something else, yes. Okay, 2 weeks. You take 2 weeks.
20th onwards, I have some difficulty, but then may I pray either before the 20th or in the first week of May?
Okay, first week of May.
I'll oblige.
These matters, written statement.
Yes, 23 days delay.
Procedural,
In fact, I have filed my written statement. Subsequently, they have raised the issue that there was a time bar. Then subsequently, my
The
written
court allowed it.
Court allowed already. Court has granted time. Accordingly, I have filed. Then
what
he raised
happened?
objection. Then there was a hearing. After hearing, then my written statement was closed.
Okay. Yes, quick.
Lordship, item number 23, Lordship. It will be adjourned, Lordship. Today I'm not feeling well.
You're looking very smart, but I'm not looking well. Yes, who's for the petitioner? You have no objection?
No, Your Lordship.
Okay. 2 weeks.
Lordship, I like to make mention of item 24, my lord, for respondent 1, 2, 3. Yeah, my lord, we had to produce the records. Records are not received yet, Lordship.
And for the petitioner, Your Lordship.
What records?
Knockma dispute, Lordship.
To 2020 matter, okay. 2 weeks,
Records
yes.
were called for in the last occasion only.
2 weeks for production of records. For the
Your
2 weeks
Lordship.
for production records allowed to respond 1, 2 and 3.
1, 2, and 3, Lordship. Much appreciated.
Yes.
I beg to mention item number 29, Your Lordship. I pray that the matter may come up after 2 weeks, Your Lordship.
29.
29, Your Lordship.
You're for?
And for the respondent number 2, Your Lordship.
Similar prayer for 30 and 31, Your Lordship.
What's the matter about?
It's a Microfed matter, Your Lordship. The petitioners are the employees of the Microfed, Your Lordship. They're coming for the gratuity and leave encashment, Your
But
Lordship.
those matters already settled
No, Your
over and
Lordship.
over again.
Thanks for hearing, Your Lordship.
After 2 weeks, yes.
Highly obliged, Your Lordship.
Then today also will have to go, Your Lordship.
28 will have to go also, 28.
28.
Who's the petitioner 28?
Mr.
And
Ayub
for the
Khan.
petitioner, Your
You're the
Lordship.
petitioner.
Yes, Your Lordship.
We'll have it together after 2 weeks.
Lordship, yes.
Yes, can you same day? 28, 29, 30, 31, yes.
Similar prayer for
Babla,
item,
Your Lordship.
for item number 33, Your Lordship. I pray for 2 weeks' time to obtain.
Then my hearing list has been extinguished or exhausted. Oh, Mr. Mazga is not here.
Well, here, my lord, it's a matter of petitioner is supposed to take instruction.
Yes, Your
Only
Lordship.
because what he wanted, my lord, that he should be paid for the work he has completed.
I haven't get any
But that
specific
is with this union government, correct? They're paying him, or you're paying to his PLUD.
I'm also there. See, this matter was hard matter, if Lordship remember. This is with regard to blacklisting, my lord. Blacklisting.
Yes, I remember. But then, only 1 week.
It's only for instruction, my lord. There should approach the civil court on non
2 weeks' time, Your Lordship.
Why 2 weeks' time?
For specific instruction, Your Lordship.
My Lord,
Why are you lingering this matter?
My Lord, we are not getting specific instructions in this. My Lord,
Just give us instruction, then we'll dismiss it.
my Lord, just 2 weeks, my Lord, as last chance, my Lord. After that, I will
How
argue,
much,
my
you
Lord. My Lord.
How much time can you adjourn this matter?
My Lord, as a last chance, my Lord. After that, we will argue, my Lord.
1 week for a time. Allowed last chance to the petitioner to obtain instructions.
My Lord.
Failing which the matter will be closed.
My Lord, we will hear on merit, my Lord. After that,
What you heard on merit?
my Lord,
The court expresses views that whatever relieves is not before the writ court.
my Lord. 2 weeks, my Lord. That's the last chance, my Lord.
2 weeks last chance, yes.
My Lord, obliged.
Your Lordship, I beg to mention item number 32. At the joint request of both the parties, Your Lordship, this matter can come up after a week.
Don't see the other party.
Your Lordship, search.
This matter we should finish it off.
Your Lordship is
You
still
already
awaiting
argued,
instructions.
correct?
Instructions are still awaited, Your
Regarding
Lordship. It was regarding the OBC.
OBC certificate,
whether it can be accepted, whether the OBC granted by Assam
the state of Assam has to be accepted.
can be accepted by state of Meghalaya. See, there's that presidential that's under Article 266, Article where they see the presidential problem regarding which are the OBCs, which are is there. It comes within there anyway. 1 week's time.
And my lord, I hear also that OBC is based on the place of origin, my lord. That judgment is there.
Yes.
May I please, Your Lordship? I beg to mention item number 21 of the mandate.
20?
21.
21. (19) matter, 1 week. Yes.
Let the interim order shall continue.
Interim order not continue anymore then. Okay, interim order the next date, yes. Continue next date, right?
Supplementary list, item number 1.
I don't think Yes. So sorry, petitioner. Mr. Nath. No one's there. Now let me for petitioner list after 1 week, yes. Strange, item number 1, the list, and there's no appearance.
Item number 2.
Wait, please, Your Lordships. This is in fact the second round litigation involving the minor check station at Mukindur.
What happened?
Now, my lord, if Your Lordship recollect, my lord, in spite of...
disposed of by this court?
Yes, yes, Your Lordship. Disposed of, Your Lordship. Lordship has set aside. I was the highest bidder. I cleared in the technical bid, came to the financial bid. So instead of picking me up, I'm the highest bidder, they picked up the second highest bidder. So that was challenged before Your Lordships. So Lordship, after hearing all the sides, they have raised an objection that my land is not suitable. But our contention was that if land was not suitable, how was cleared in the technical bid? So ultimately, Lordship said that I fulfill the conditions. But Lordship has observed that if there are some additional norms, etc., then District Council can look into it. And Lordship has set aside the appointment of second highest bidder. That was set aside. So matter went back to the District Council. Now, District Council looked into the matter afresh with reference to Your Lordship's observation and judgment. So they have not revised the norms. They have issued an order in my favor, Your Lordships. I will take my lot.
They settled with you. The term for how long?
3 years is normally 3 years. My lord, I can take Your Lordship to page 60, Annexure 8.
60.
Yes, my lord. Now, this is addressed to me, my lord. Dated Lordship will see 26th October 22. With reference to the subject letter cited above, I am directed to inform you that the Executive Committee, Janti Hills District Council, Jubai, in its meeting held on such has looked into the matter of Mukindur Checkpoint Station for identifying, detecting illegal trading by non-tradable commercial vehicle without license, vide High Court order dated such and such. After deliberation, the Executive Committee has decided to allot the check station may be considered to the highest bidder similarly redundant now if the location of the land to be used for the purpose of the taxation is feasible for the check station with levy. Therefore, you are requested to arrange a suitable land with the levy that can be used for the purpose of operation of the check station so as not to obstruct, disturb movement of the traffic along national highways. Kindly note that you are to comply with the requirement on providing land levy for operation of the check station within a period of 2 months from the date of issue of this letter for consideration of the Executive Committee deemed proper. So this was, I was expecting, I got a better land now, my lord, invested money for building up the infrastructures, inform them, I have done my part. But in the meantime, what happened, my lord, election was notified. I understand, my lord, they had not issued the formal order, maybe because of the election. Moment the election was over, a new regime took over, my lord, I don't know, there are powerful lobbies and all those. They have strangely, without even a shock.
How is the new regime? District Council, no elections are there.
My lord, I think normally whenever, my lord, general elections are notified, they also, my lord, never issue any orders. You know. Maybe because of that, my lord, I have not approached. So I have done my part, made huge investment, build up infrastructure. Now to my shock, my lord, comes this at page 62. At page 62, my lord. Dated 16 March 2023. Executive Committee decision
Just say one, tell the court one thing. After you arranged alternate sites, there was an inspection done and it was found suitable?
Thereafter, my lord, I have informed them that as you required, I have done everything, my lord. Yes. I have no instruction, they have inspection and all, and this is not the reason. Reason is something else for cancellations.
Right, okay.
My lord, I'll take my lord to 62. Executive Committee decision dated 14/3 recalling the decision dated such and such.
Yes.
Madam, I am directed to inform you that Executive Committee JHS Dusai in its earlier decision such and such has resolved to offer appointment to you to operate the council checkpoint at Mukindur, provided you make necessary arrangement for suitable site to operate the checkpoint. The said decision of the executive committee was communicated to you such and such. In subsequent development, one tenderers had issued a legal notice on ground that if appointment is given to you for operating the checkpoint at Mukindur by changing the site not originally offered by you at the time of submission of the bid, same would be against the tender documents and the terms and conditions stipulated therein, and it was impressed upon the executive committee that any action in that regard would only lead to fresh round of litigation. Therefore, the executive committee in its meeting dated such and such, upon deliberation and discussion of the matter, had decided to recall its earlier decision dated such and such, and accordingly the consequence thereof, letter under reference above issued to you, stand cancelled. Now, only in the ground, now I made inquiry who issued this legal tender. The very person who was given the first appointment initially and whose appointment was cancelled by this court. Now, who is he, my lord? It is not.
He filed a legal notice.
He issued a legal notice. Saying, my lord, he is out of consideration, his appointment has been set high, he is nobody, and it is not a case, my lord. I understand. If the settlement were made, revising the, my lord, requirement, original land I offered, lordship also held. This is all right. This is as per the requirements. So only what they did, they offered me the appointment and they said you get a better land. Additional condition they put with a successful bidder. Now what business this man has, your lordship?
Yes, who's appearing?
My lord, at least, my lord, at this.
Should I accept notice on behalf of the respondent 126?
Very good. What do you have to say?
To take instructions.
My lord, only thing I am fearing, your lordship, I sought for a stay, my lord, of entire order, but my learned friend requested that the standing counsel, Mr. Mojika, is out of station. So this matter may come up again. But in the meantime, what I am fearing, my lord, there are very powerful lobbies, my lord. Now they are intending to issue fresh tender. And my lord, to get it settled with somebody else. So, my lord, at least till then, my lord should not issue fresh tender.
Counsel for the petitioner.
If I may further submit. Insofar as the check gate is concerned, there is another petition which is pending before the other bench. Now, in that case, the court has allowed the district council, because there was a challenge by the state government saying that we don't.
You are allowed to run departmentally.
They are running departmentally.
I mean, that is outside the.
There are other, my lord, run by private, let's say, I have stated. That should not come away.
Mr. SNL, counsel with the petitioner, issue notice, Mr. ML, no, your counsel present on behalf of all the respondents. All the respondents?
All respondents.
Yes, so no further notice for a change.
With regard to check station at Mukindur, my lord, there are many check station at Mukindur.
Etc.
Check station at Mukindur, my lord.
Item number 3.
They are trying to, make the whole thing.
I think you are.
Yes.
May it please your lordship. Lordship, if I can take a minute of lordship's time just to refresh lordship's memory. Lordship, I am the tenant. Court of Assistant District Judge, my lord, passed an order, an interim order, on an application which I had preferred for restoration of electricity.
1 second. Urban Areas Rent Control Act. You are a tenant, correct?
I'm the tenant. So electricity was disconnected. I preferred an application, my lord. Interim order was passed on 22nd February by Assistant District Judge. Interim order contained two aspects. One, restore electricity pending disposal of that miscase which I had filed. Number two, asking for show cause hearing for steps to be taken for issuance of notice to the landlord, my lord. Against that order, appeal was filed under Section 8 of the Rent Control Act by the landlord. Appeal, my lord, was admitted. Appeal was disposed. Appeal was allowed, my lord, without issuing notice to me. So, lower court's order was set aside. Lower court's order, which had granted me the right to receive the electricity, was set aside without issuing notice, without hearing me, my lord. So, lordship may also recall that is the only ground that I have agitated. So, in other words, my lord, my only grievance is the fact that the basic rule of natural justice, or the ultimum partem, has not been complied with, my lord. Now, I concede, my lord, that there could be certain situations where the issuance of notice, where the requirement to hear the other side is not, can be deviated from, my lord. Supreme Court has listed out situations in which that deviation is permissible, my lord. With Lordship's permission, I'll just place the judgment for Lordship to consider whether in my case, in this case, this deviation was permitted to be undertaken by the district judge, my lord.
So your grounds only that you not heard before the appellate court. That's it.
As of
You'd
now,
be satisfied if we remand it back and allow you an adequate opportunity of hearing for the appellate court.
I'm more than happy, my lord. The district judge's order, if Lordship is convinced, district judge's order will have to be set aside, thereby reviving the.
If it's remanded, naturally be set aside. I mean, it's
thereby reviving the assistant district judge's order, granting me the electricity. I am prepared to place whatever submissions I have. I am of the opinion, my lord, with all due respect, appeal is not maintainable before the district judge.
But that will go before.
Exactly.
Already,
this is not
the thing is that if it's been your main contention is that this matter was taken up in appeal.
Yes, ma'am.
Remanded back to the court of the assistant district judge, correct?
Yes,
without hearing you.
Without hearing me, my lord.
That's it.
So as I had submitted.
So you feel that you have something to say that first appeals are maintainable, and that secondly that the prerequisites of the act has been fulfilled.
Naturally, my
and that the order is interim in nature.
Yes, my lord. All those submissions are there. The correct forum is the.
Mr. Sen, what do you say to that?
Lordship, if I can just point out this judgment, my lord.
Sorry, please.
Yes. Lordship, this is from 1993. Para 77, my lord. Para 77, the rule of audi altum partum is not attracted unless the impugned order is shown to have deprived a person of his liberty or his property. In the present case, no such consequences. This is on the facts, my lord. So, my lord, it can be deviated if the order in question does not deprive a person of his life or property, my lord, of his liberty or property. In this case, district judge's order has deprived me of a valuable right of electricity of property without following audi altum partum, my lord. Similarly, my lord, just one more paragraph, if I can point out, para 80.
This is a Bofors case.
Yes, my lord. Yes, my lord.
Yes.
Para 81, my lord. Para 81, thus, there is exclusion of the application of audi altum partum rule to cases where nothing unfair can be inferred by not affording an opportunity to present and meet a case. This rule cannot be applied to defeat the ends of justice or to make the law lifeless, absurd, stultifying and self-defeating, or plainly contrary to the common sense of the situation. And this rule may be jettisoned in very exceptional circumstances where compulsive necessity so demands. So, Lordship, if issuance of notice leads to a situation of absurdity, then it can be avoided, my lord. Lordship, if I can be permitted an example, Lordship, day in and day out passes an order for issuance of notice. Now, that is an order that Lordship passes in the absence of the other side. Now, to issue notice, will Lordship issue notice to them to say whether notice can be issued? That is an absurd situation, my lord. In such situations where absurdity is created by issuance of notice, it can be avoided. It should be avoided, my lord. My situation, there is nothing absurd, my lord. There is nothing absurd. I was required to be issued notice before my property is taken away. That was not done. So, my lord, the issue out here, in my very humble submission, boils down to a very simple question that Lordship will have to pose for the respondents. Was I heard before the order in my favor was set aside? If the answer is no, I was not heard, and it has to be no, then that should, in my respectful submission, be the end of the
subject. What he has to say, yes,
absolutely.
There are many other judgments, Mr. Jindal,
yes,
regarding like the necessity of being heard, especially service matters.
Absolutely.
Whether it affects it is
absolutely.
It's not.
There's also the exception that if it's an empty formality, then it is not required.
Exactly.
Malud, apart from the issue of non-issuance of notice, there's a second ground taken in the appeal, in the revision application, with regard to the maintainability of my appeal before the first appellate court. Now, I would have been happy had this been the only case where simply because of non-hearing, the order should be set aside and they should be heard by the trial court and put back to that place. But the problem is, what he's asking for is revival of another illegal order. And the reason why I call it an illegal order, kindly have the revision application, page 24. My friend's case here is that the order impugned before Lordships is an illegal order because they were not heard.
No, but in your case...
But the order that is sought to be revived is also an illegal order, my lords.
Not really, because it's in the interim stage. It's not been disposed of.
I'll point out why.
Okay,
there are good grounds, my lord.
Yes.
if your lordships have, this is the order dated 22/2/2023. Now kindly see, this is an application which was filed by the defendant in a pending suit where I am the plaintiff. And I don't understand the reason why, but without issuing notice to me, without even serving me a copy of the application, the matter was heard and an order was passed on the very same day. Now under Order 39, Rule 3.
This was filed under what provision?
That's the other interesting part, my lords. It's filed under Section 6 and Section 7 of the Urban Areas Rent Control Act, read with Section 94 and 151.
Supplemental relief.
Correct. But now 94 itself enumerates multiple situations in which the court can exercise jurisdiction. But it must be prescribed by the rules in the first schedule, Order 1 to Order 51. Now the question is, what power does the court exercise before passing this interim order? If lordships have the Urban Areas Rent Control Act, there is no power to pass an interim order. No power. And lordships have done a comparison with several other state statutes. For example, the Delhi statute, the Maharashtra statute, or the Punjab statute clearly vests power with the court to pass an interim order, pending an inquiry. Pending an inquiry and pending a show cause by the landlord. But in this case, the State Act does not vest the court with any such power. Now the question is, which power did the court exercise? My submission before the learned trial court was very simple, that an application under Section 7 seeking restoration of any of these essential supplies must be made as an independent application. It cannot be tagged along with the pending suit. For the simple reason is, because once you file it with the suit and you ask for invocation of Section 94, it creates an anomalous situation. For the simple reason that the question is, where do I file the appeal? Now my learned friend's case cannot be accepted for the simple reason. This is my difficulty in accepting this. He claims that the interim order which was passed ex parte is one under Section 94/151. That is his ground that he's taken a categorical ground. Now, my lords are aware, Section 94 has completely different consequences. The scope is completely different as compared to Section 151. An order passed under 94 may be appealable, whereas an order passed under 151 is not appealable. Now, he himself is not very clear in his petition under what provision has the court passed his ex parte order. Now, kindly see the ex parte order. This is at page 26.
That's what the court wants to know. Under what
provision? Now, he is supplementing the order of the learned trial court by saying it's under 94/151. It's for the court to indicate in the order.
No,
the
but
order should have been self-evident.
This trial court relied upon Section 6 of the Rent Control Act, that the duty of landlord is to provide electricity.
Right.
So looking at prima facie, the only thing prima facie without going to technicalities, what the trial court had done was fine, like it's your duty to give electricity, and so like you've disconnected, reconnect, that's all.
Which is not permissible. I'll point out why. If lordships have the Urban Areas Rent Control Act,
yes.
kindly have page 73
of
it begins with Section 67.
Okay, sorry.
I found this online.
Right.
May I just take lordships through Section 6 first, indicating the duty. The language is very important. Every landlord shall be bound to keep waterproof any house which is an occupation of a tenant, and to carry out other repairs which he is bound to make by law, contract or custom, and also to maintain the existing essential supplies. Kindly take note of the expression existing supply. So therefore, unless and until this is existing, the dual relationship between the landlord and tenant,
why do you say it's not existing?
Our plea is that this was disconnected in 2020 after the first lockdown. As soon as certain relaxations were ordered by the government, it was disconnected. My friend has conveniently not enclosed a copy of the petition.
Disconnected? Why disconnected?
There was continuous default on the part of the on behalf of the petitioner. As a result of that, he was aware of this. Now, I have photographs to show that he has electricity.
Have you brought your plaint on record, your ejectment suit?
No, he's the petitioner, my lords. It is not on record. Which is what I'm saying. He should have brought it. I would have indicated from the pleadings itself. There are specific pleadings, my lords.
Read the copy of the plaint.
Very well, my lord.
Everything stems from there.
Correct.
Very well, my lord. But lordship will kindly note the order of the ADJ is not under challenge before this honorable.
No.
All these submissions relate to
whatever it is, we have to look at the larger picture.
Very well, my lord.
That's only yes.
And because lordships is exercising jurisdiction under 227.
Exactly.
So, So this says that the duty of the landlord, the obligation, is to ensure
So
and
your first
maintain.
ground is that there was no existing supply.
There wasn't.
So
There
it's not incumbent
So there was
upon
no
you,
contractual
upon you to restore.
Lordship, there was no
not
contractual
existing.
obligation. Precisely.
Okay.
Now, can you see section 7?
Yes.
If the landlord neglects to make such repairs or to maintain such existing essential supplies and services as he is bound to do under the provisions of section 6, the court may, on the application of the tenant, direct the landlord by notice to appear before it and show cause against the application of the tenant. So therefore, it must be premised on an application by the tenant, and then show cause has to be issued. So under section 7.1, what the court has the power to do is simply issue a notice to the landlord to appear. Now kindly see subsection 2. If the landlord fails to show sufficient cause, the court may direct him to make such repairs, or as the case may be, to take such measures for the restoration of the essential supplies and services as contemplated in section 6 within a period fixed by the court. Now, between the situation contemplated under subsection 1 and subsection 2, the court is not invested with the power to pass any further orders or any other kind of orders. Now, kindly see subsection 3. If the landlord fails or neglects to make such repairs or take such measures within the period fixed by the court may, on an application, now this is a second application that will have to be filed by the tenant, permit him to make such repairs or take such measures as the case may be.
This is ancillary, and that is different. Yes.
So
what your main submission is that there was no existing supply, so question restoration, and number 2, that even if there was any prey on his part, it should first go, the notice should go to you, should be heard before this.
And I'll point out why. The difficulty in invoking section 94. Kindly have section 94, Lords. I was examining and hoping that I would learn something in the process, but there is some difficulty in accepting their contention as well.
Yes.
So section 94 reads supplemental proceedings. In order to prevent the ends of justice from being defeated, the court may, if it is so prescribed. Just pause here for a moment, my lords. This expression has been defined in section 2. The expression prescribed. Kindly have section 2, subsection 16. It reads, prescribed means by rules. And the expression rules has been further defined in subsection 18. It reads, rules means rules and forms contained in the first schedule or made under section 122 or 125. So first schedule will be orders 1 to order 51. Now kindly see the situations enumerated under A2C. Issue a warrant to arrest the defendant and bring him before the court to show cause why he should not give security for his appearance. And if he fails to comply with any order for security, commit him to civil prison. So this is not what they're invoking. Direct the defendant to furnish security to produce any property belonging to him and to place the same.
What he's saying is 94E, Mr. Sen.
If it is 94E, if he stipulates, I have no difficulty. And I'll point out why. Kindly see C. C would be grant of temporary injunction and in case of disobedience, commit the person guilty to civil prison. If it's under C, I have some difficulty. Then I would want to defend it. If it's under C, I have no difficulty. Because then there is no obligation on my part to comply with the order. Then I would resort to whatever procedure has been laid down under subsection 7.
E.
Lordship. Yes, if it is E, I have no difficulty. If he stipulates it's under E, because he says it's 94 without indicating whether it's A, C or E, and then he says it's /151. It can't be both. 94 and 150 are completely distinct jurisdictions.
This 94 was inserted to meet these kind of situations. In fact, the suit's going on, the order threats already gone, then some situation arises where that these are supplemental proceedings. So that is the intent of the of the court.
Lordship, this is exactly what I had in mind.
Yes.
There is a decision of the Honorable Supreme Court dealing with this particular aspect, specifically section 94. This is Wareed Jacob. If Lordships will kindly turn to page 388.
Yes.
May I just take Lordships through section 6, para 6 onwards. if Lordships have it.
Yes.
The Civil Procedure Code 1908 applies to all proceedings in courts of civil jurisdictions subject to any special or local law or any special jurisdiction under any other law for the time being in force. The main feature of the court is its division into two parts. The main body of the court consists of sections which create jurisdiction, while the rules indicate the manner in which the jurisdiction has to be exercised. Section 9 states that the court shall have the jurisdiction to try all suits of civil nature except suits which are expressly or impliedly barred. Section 9 falls in Part 1 CPC, which deals with suits in general. Part 2 deals with execution. Part 3 covers sections 51 to 64. Under Section 51 CPC, subject to limitations and conditions as may be prescribed, the court may order execution of the decree by delivery of any property specifically decreed, by attachment and sale, by arrest and detention, by appointment of receiver, or in such a manner as the nature of the relief granted may require. Therefore, attachment is a part of execution process. Part 3 CPC deals with incidental proceedings like power of the court to issue commissions, letter of request, etc. Now, this is important, my lords. Part 6 CPC deals with supplemental proceedings which cover Section 94, which inter alia empowers the court to pass interim orders depending upon the circumstances prescribed by the rules. In case of Manohar Lal Chopra versus so-and-so, it has been held that the effect of the expression "if so prescribed" in Section 94 is to prescribe the circumstances in which courts can exercise or grant a particular relief, and ordinarily the court is not to use its inherent powers to make the necessary orders in the interest of justice, but to see whether the circumstances of the case come within the purview of the prescribed rule. Therefore, in a case where the plaintiff seeks temporary injunction, courts have to ascertain whether the facts of the case fall under Order 39. That it is in the incidence of exercise of power of the court to issue temporary injunction that Section 94 has a role to play, and that Section 94, however, does not take away the right of the court to exercise its inherent power. In the same judgment, Section 151 is also analysed. The Apex Court in the same judgment has held that the inherent power has not been conferred upon the court by Section 151. It is a power inherent in the court by virtue of its duty to do justice between the parties before it. That Section 151 merely recognizes the existence of the inherent power of the court. Therefore, even if in a given circumstances do not fall within Order 39 CPC, the courts have inherent jurisdiction to issue temporary injunction if the court is of the opinion that the interest of justice requires issue of such interim injunction. In the case of so-and-so, it has been held by this court that the inherent power of the court under Section 151 CPC is in addition to and complementary to the powers expressly conferred under CPC, but that power will not be exercised in conflict with...
So what you're trying to say is that once express provision is there, the 151 should not be invoked.
Cannot be. And I'll just read out the last two paragraphs of that, 10 and 11. In the case of Jagjit Singh Kharana, has been held that a temporary injunction may be granted under Section 94C only if a case satisfies Order 39 Rule 1 and 2. It is not correct to say that the court has two powers. One to grant temporary injunction under Section 94C and the other under Order 39 Rules 1 and 2. That Section 94 CPC shows that the court may grant a temporary injunction thereunder only if it is so prescribed by Rule 1 and 2 of Order 39. The court can also grant temporary injunction in exercise of its inherent power under Section 151, but in that case, it does not grant temporary injunction under any of the powers conferred under CPC, but under powers inherent in the constitution of the court, which is saved by Section 151. And lastly, Para 11, my lords. The above discussion shows that the source of power of the court to grant interim relief is under Section 94. However, exercise of that power can only be done if the circumstances of the case fall under the rules. Therefore, when a matter comes before the court has to examine the facts of each case and ascertain whether the ingredients of Section 94 read with the rules in any order are satisfied and accordingly grant appropriate relief. It is only in cases where circumstances do not fall under any of the rules prescribed that the court can invoke its inherent power under Section 151 CPC. Accordingly, the courts have to grant relief of attachment before the judgment if the circumstances fall under Order 38 CPC. Similarly, courts will grant temporary injunction if the case satisfied Order 39. So depending on the circumstances falling in the prescribed rules, the power of the court to grant specified reliefs would vary. Now, the reason why I'm relying on this is because they claim that the relief has been granted not in exercise of powers under 7.1 or 7.2, but it is under 94/151. Now, this judgment makes it very clear the very distinct jurisdictions. You cannot invoke both together. So the question is, if my friend stipulates that this is a order which has been barred...
The order is silent about that.
It's silent. He cannot supplement that.
It does not say it's under 94E or
Precisely.
under 151. It does not say anything.
Now, just for a moment,
the
if
only
we
thing is that, see, the things as a suit has proceeded, now whether existing connection or not, but supplement proceedings come when there's a dire need for some relief or some, like interim kind of nature. Suppose the nature of the suit changes and you have to get orders from the court to prevent the wasting of the property. So that 94 would come in at that time. But the thing is that it's in the nature of order 39 rule 1 and 2. But in this case, are you trying to say that the order, it's like in substance cannot be sustained, because it's not as unsustainable because of the non-mentioning of the particular...
No, I have no difficulty with the non-mentioning. I mean, that is a settled position. The question is if the court had the jurisdiction and if it has excised the jurisdiction correctly. Now the question
one
here is,
might have that if
it is under 94,
before any relief can be given, this court feels the same way also, at least the notice should have gone. That is the only thing. So the baseline is like, okay, fine. One part of his arguments is that it was taken an appeal by you. I mean, no notice given to him, and it was reverted back, remanded back. And your case is that okay, the order is under challenge here, but the order under appeal is like patently wrong because there was no notice given you, and the interim relief was granted, and that was under what provision, which is unknown.
Unknown.
That's all. Yes.
So it appears both the orders were illegal. Both the orders were passed ex parte. The first order is patently illegal because in my suit, the defendant cannot come and take out orders. At least a notice should have been given to me. I could have been heard on that very day. But instead of that, an order was passed. Now, when we carried that in appeal, I never insisted that the matter should be heard ex parte. In fact, I was of the view that the order will be passed by issuing notice. I was only praying for a stay. Instead of granting the stay, the court has in its own wisdom directed passed the final order. Now, they are challenging that order. Now, there's only one difficulty. As I was saying, if he stipulates it's under 90, it's not under 94C. It's under 94E. No, I'm just saying, which is why. Well, he claims in his petition it's 94/151. The difficulty is there.
Can claim your convenience, but then how can you stipulate?
So if
can we put words into the court's mouth, like
No, absolutely not. Which is what I was saying. They cannot supplement the order of the court.
It's not his application. He says, okay, fine. My right. I make it under this like 226, 227. Okay, fine. I surrender 226. It'll be under 227. Then you can't make 226, 227/227 applications anymore.
The reason why I say this, my lords, my only fear is that if the order is treated as an order which is passed under the rules prescribed under Order 39, then they will be at liberty to file an application for disobedience. That is the only difficulty. Which is why I was saying, there must be it must be indicated to us.
The thing is that the court here, we have to look at supervisory jurisdiction, to correct the procedure. Suppose just to write, course correction in a sense.
And it is not
detect any, in the excise jurisdiction by the court below has been, it's
Lordships. And I would also humbly submit, since Lordships are exercising jurisdiction under 227, we don't have to be confined to the order under challenge.
Right.
Lordships can look into the order which was originally passed by the trial court. So both the orders may be set aside, we may be heard by the trial court itself, which the trial court was hearing. Now, there's another additional aspect. Pursuant to the order of the 6th of March, 2 other orders have been passed by the learned trial court. So after the order of the 6th, that order was put up before the trial court on the 20th of March. Now this reads, as directed by the learned district judge in order dated so-and-so and FAO number so-and-so, the instant miscase is to be disposed of within 3 weeks of the order. Heard learned counsel for the petitioner to take immediate fresh steps.
Hence, yes.
And fix 24. Now what they did not challenge the order of 6-3 immediately. They issued fresh steps to us. So we had already received a copy of the application when they had moved in the month of February.
They are sailing on 2 boats.
Correct. So they have complied with the order of the appellate court. Now what happened? This is very interesting, Willow. So the court fixed this matter on the 24th for hearing. At this point, there was no interim order operating in their favor. And in compliance with this particular order of the 20th, they issued notice to us, fresh notice. The matter came up before the court on the 24th and it was heard. And I'm sure my friend will not dispute me. He renewed his prayer for an interim order again because the court was going on leave immediately thereafter. Now kindly see the content of this order. Upon hearing both the learned counsels, this court has observed that the learned counsel for the petitioner has stated that the electricity of the suit premises was disconnected by the opposite party on 18/2/23, while the learned counsel for the opposite party submitted that there was no electricity in the suit premises since the year 2020. Both learned counsels further submits that there is nothing on record to substantiate the submissions made by one against the other, On perusal of the petition filed by the petitioner, this court has observed that there is not no electricity bill receipt enclosed along with the petition, and on perusal of the show cause filed by the learned counsel for the opposite party, also there is no documents enclosed to show that electricity was disconnected in the year 2020 and not on 18th.
So the matter rests at that.
So thereafter, the court directed both the parties to produce certain documents. I am aggrieved with this order for the reason that the court cannot adopt this procedure, but that's a different issue. But the fact does remain, these orders have not been included or been referred to in this particular revision application. So they complied. In compliance with the order of 6.3, they issued fresh notice, they participated in the hearing. On the 24th, when their prayer was not accepted by the court, they decided to file this revision application, challenging the order of the first appellate court.
Okay.
Can I respond, my lord?
You want to respond?
I'll be required to, my lord. Just a few minutes, my lord.
Yes.
Lordship, the intention of the respondent is very apparent, that he wants to entangle this honorable court in unnecessary facts and unnecessary aspects of the matter, my lord.
Yes.
Lordship, about half an hour has been taken by the respondent, but the basic question still remains unanswered.
Yes.
Was I issued notice by the appellate court or not? Answer very clearly is not.
Yes.
I was not. Instead, much has been made on various provisions.
See, both of you are aggrieved.
Absolutely.
They're cutting everything short.
Yes, ma'am.
He's aggrieved not being issued notice by the trial court,
Very
and you agree for not being issued notice by appellate court. That's it.
Yes, madam. Yes,
leaving aside everything else.
Leaving aside everything else. Now, Lordship is very right. Leaving aside everything else, all submissions that have been advanced on the merits of the matter. The fact is, number one, I am a tenant.
And you have your rights.
I have my rights. Number
Yes.
two. Number three, I am in possession, my lord. And Supreme Court is very clear. It is on the issue of possession that the question of whether or not to grant electricity has to turn, my lord. I'll just place one judgment, and I will rest, my lord.
Even if you're an unlicensed occupant, you're entitled to it.
Absolutely, my lord. Absolutely, my lord.
There's a provision in LC Act with that section.
Under this act itself.
And it's LC Act itself. There's a provision for a supply of electricity connections. Anyway.
Yes, my lord. Yes. Lordship.
No, we'll not go there, yes.
Yes, my lord. I'll just place this judgment. This is from 2009, my lord. Just one line from this judgment from para 5, my lord. Supreme Court judgment, my lord, para 5. The question whether the appellant is a tenant or not shall be gone into at the time of disposal of the suit, similar to our case, when the evidence would be produced by the parties in support of their respective cases. Since there is no dispute that the appellant is in possession of the suit premises, claiming to be a tenant, the electric supply to the premises in question should be restored. Therefore, the High Court in the exercise, etc., my lord. Many judgments are there on the same line, my lord. If I am in possession, rightly, wrongly, legally, illegally, I cannot be denied the electricity. So whatever are the merits of the matter, and a lot has been submitted today, answers are there, but with all due respect, this is not the correct forum for that. Matter may be remanded. We'll make our submissions before the appellate court, but till that time, my lord, till that time, the electricity has to be restored. I am in possession. There is one just additional aspect which needs to be addressed about the contention that these are not existing facilities; they were disconnected.
That's the only question that bothers us, court.
Yes, my lord.
Whether it's existing, yes, under the Land Control Act, you entitled to it.
Very quick answer to that, my lord, can be found in the show cause which they have themselves filed in the trial court, my lord. That show cause
before the court.
It is before this court. Show cause, my lord, is at page 27. Para 9 of the show cause, my lord, at page 29. At page 29, para 9 is there, the second portion of para 9, my lord. It is stated that, my lord, it is stated that the opposite party is renovating his hotel in the property, and renovation works are ongoing for some time now. The original connection to the suit premises was being utilized for renovation-related activities by the workers, and after completion, the same was disconnected recently on 18/2/2023. There is an admission on record.
It doesn't make any sense. Instead, opposite party is renovating his hotel. Whose hotel?
My hotel. His hotel.
And renovation works are ongoing sometime now. The original
Lordship, the original connection to the suit
utilized for renovation
was being utilized for renovation
now
related.
whose premises?
I'm not sure. It's his show, my lord. What is important, what comes out is that.
I mean, at least the courts understand what's being said.
True,
in
my
this
lord.
paragraph.
True, a little.
Please just explain that.
Yes, just read it. The state opposite party is renovating his hotel. That's
It's a
your hotel
multi-story
in a
building.
property, and renovation works are going on for some time now. Okay, the original connection to the suit premises
was being utilized. For renovation related
So what has happened
activities by the
is that
workers.
the submeter is not installed in the suit premises, which is the
Very
tenanted
complicated.
premises. It
Who
is outside.
submeters this? Does he have a bill in his name?
No, nothing. So the
You're a tenant. You don't have a.
The
I mean, how do you pay
submeter is
electric bill?
outside.
That's the arrangement from the 2005, since the time I've been a tenant. He says you have to pay XYZ amount, I pay that XYZ amount by check. So records
is
are
his
there.
case.
So do you have any
Lordship?
See now.
Lordship, this is one aspect.
Original connection to suit premises being utilized for renovation. What do you mean by
I'll explain
what
what
is
has
the original
happened.
connection? That
Maybe
there
better
was
choice of
connection
words.
to-
I'll explain.
There was a connection to suit premises, which was and now you have taken it away to utilize for your renovation related activities.
No, what I'm saying
And the same was disconnected on 18.2.
I'll explain that.
Lordship, the show cause
And-
cannot
and
be
were
added
you-
to.
Now, were you tapping into the connection prior to?
No, they weren't.
Nothing of that sort. my lord. Nothing of that sort. There is a clear concession I submit that the
Pass
same.
orders, yes.
I'll just explain what this means.
Lordship.
The submeter is not installed in the tenanted premises, it's installed outside. Now, this was disconnected as far as the supply to the tenant goes. That supply was disconnected in 2020. We have been using the supply from that submeter for our own purposes for the renovation of that entire building. That is what it says. They're misconstruing what has been said here.
So you mean
Why would I
you
make a
mean
concession
you
of this
cut the
nature?
supplies in 2020?
From 2020,
You've
the
cut the
supply.
supply.
Yes.
You never
We're
did
admitting
anything
that
about it.
position.
Lordship,
Yes.
Lordship, I run a business in those premises. It's an apparel business, clothes business.
Very interesting name, I saw. Yes.
Lordship, now I need electricity constantly from 10 in the morning till about 8 in the night. And it has to be proper electricity, not a generator. Generated
How are
electricity.
you managing it?
I am managing because electricity has been
Do you
there.
have any
It is
to show
illogical.
that you've been paying the bills till 2023?
I have submitted the same on 3rd of April. I submitted the same before
Just
the
for a
trial
moment,
court.
Alex.
We're not
These
going
are
to go
very
there.
recent pictures. The reason is
Lordship,
because they have said
these proceedings
that
cannot-
there is no electricity whatsoever. There is no electricity whatsoever. These are pictures to show, very recent pictures, for many days that there is electricity in the premises. He's been running on the basis of an inverter, and I've stated that in my own application minutes.
Lordship, these proceedings cannot be turned in that particular direction.
Yes, we'll pass orders. Yes.
Highly wished.
I will pass open court. Last pass it. Yes.
Very good. Obliged.
Highly pleased.
Main list.
Next.
Main list, item number 1.
May it please the Lordship. Before the state respondents, we had on the last occasion prayed, since this is a challenge made to the land acquisition process, both in Jente Hills as well as East Khasi Hills. As far as Jente Hills is concerned, we'd already filed our affidavit. What was left out was the affidavit for East Khasi Hills. Lordships had permitted us. We're filing it in the course of the day, my lords.
We may be allowed 2 weeks' time to file our rejoinder.
Yes, and the council response for 29 submits that you have to be filed in the course of the day, list thereafter.
2 weeks.
After list after 2 weeks.
2 weeks.
For a joinder, if any.
Highly pleased.
Highly obliged.
2.
Very good.
Item number 2.
Mr. Lordship, in this case, if this matter may be taken after 1 week, I'm not fully prepared today, Your Lordship.
You have been keeping well for some time. I hope you're taking proper treatment. Yes,
Well, only if the records of the DPC, if that may be called, because that will be relevant in this.
But the only thing you say that the reason that given was
They were waiting for
Incorrect.
organization of some others who are work charge employees, so that those records will be necessary, my lord, because your lordships will
let him, what do you want to say?
Let this take up for hearing, then if required is if
We'll hear that 1 week. Let's see whether you made any ground for review.
My lord.
Yes, just after 1 week.
No, please, Your
At the request of Mr. H. Abraham, who's stated to be unwell. Yes.
3.
Nothing.
What developments are there?
My lord, as far as development is that, my lord, that we have, as far as the Supreme Court judgment, we are filing a curative.
Who's filing curative? You're filing curative.
As of that, though we are not a party in that proceeding, we are present.
Because Mr. Mazumdar's matter is one, no?
Yes, ma'am.
Last time he submitted that he wanted the certain developments.
Yes, my lord, it's his matter. He could not be able to because of the Silver Jubilee celebration going on Goa. So he has requested me to.
How much time?
2 weeks. In the meantime,
4
my
weeks
lord,
for the time granted to the petitioner, yes, to obtain instructions, yes.
My
Not
lord.
for, it's for them.
No,
Not
my
for,
lord.
it's for you.
Yeah, they have also not filed a reply to this, my lord. Contempt proceeding.
You don't file a reply?
No, my lord.
Why?
No, that was the file by the authority concerned, my lord, not the contemners.
Submissions also been made that the affairs have been filed. It's not by the contemners, but by, oh yes, I remember.
Yes, ma'am.
By who?
By some authority, SO2 Alpha, my lord, not the contemners themselves, my lord. That
By
was
some other persons who stated to be authorized on their behalf. Learned DHTSI to clarify the same the next date, just accordingly and so on.
I'll have pleasure.
Item
You
number
say
4.
that they should come sign it themselves. That's
Mine.
correct, yes.
Mine.
4.
Please, Lordship, Your Lordship, we're praying for time again. We haven't received instruction yet. Revet it.
8 months,
Revet
Your
it.
Lordship. Since last 8 months, Lordship, they are not filing.
Yes,
Why? Usually they're
haven't
very
received
prompt.
the vetted affidavit from Delhi, Your Lordship.
From?
Delhi.
It's a compassionate ground.
Yes, Your Lordship.
Then compassionate grounds, long time. What is there, Mr. Pandit?
Lordship,
Tell the court.
there was order by this honorable court to consider my representations.
Yes, where's the
They
order
have-
of consideration?
Yes, Your Lordship, in page number
Page?
43, annexure 8.
What did he say?
Operating part is, Your Lordship,
43?
at 45.
No, where's the order disposing your representation, considering your prayer?
Your Lordship, 45 the order, last operating part, and then after hearing the submission advanced by the, I direct the respondent authority to examine her representation afresh and to reconsider her case sympathetically. The whole exercise should be completed within 1 month from the date of this order. Learned CGC 6 months time to constitute a committee for consideration of her case. But Your Lordship, white annexure 9, 46, they dispose of my representation, they took 9 months. Instead of and it was rejected on the ground that 46 para 3, however, as there is an earning member in the family and your family is entitled to receive family pension at an enhanced rent till 11 to 24 and there are no liabilities in the family, the competent authority in headquarter office has not
So that's
accorded.
the reason order.
Yes, Lordship, but that as per the scheme, if there is earning member, but I was dependent. So
But
as
you're
per the
receiving
scheme,
family pension.
yes, Your Lordship.
Then?
Family pension also.
You've seen the latest rulings on compassionate appointment. When
Yes,
did
recently, yes, Your
yes.
Lordship.
So,
But my case
so
is.
your case has come totally watered down. The more the years that you're surviving, it's not a question of any
But
immediate need.
Yes, Your Lordship, page number 10, there is scheme I have mentioned in para number 17. There is still there is Your Lordship, vacancy is there. There is a
Vacancies not mean you're entitled to vacancies.
Yes, Your Lordship, but they have not.
You know how compassionate appointment is done in central government? They have a roster.
Yes, Your Lordship.
So as the years go on, your roster goes lower instead of going higher. doesn't mean that you're number 1, you're number 10 now in 2023. Next year 24, you'll come number 5 now. If you're number 10 and 23, there's the other people who are more needy
Yes,
will
sir.
come on top. So
Yes.
number 10 to next year you might go down number 20, and next year after you might go number 50. Then until you grow old, you won't go to
Let them file their affidavit, Your Lordship.
There's no need for affidavit.
Yes.
If you're not indigent, if they found out, or you're
I am
getting family
indigent.
pension.
I am the daughter, and I am indigent because, Your Lordship, I was dependent fully on his income.
Who's drawing the family pension? Your mother?
Mother.
So then you're getting it in an enhanced rate now.
But the family pension should not be counted, Your Lordship, while considering the application.
Where you should have scheme that?
Your Lordship, page number 10,
Yes.
para 18.
Yes.
There is a scheme I have enclosed also, but I have mentioned here. The scheme for compensation appointment was conceived as far as 1958. Since then, number of welfare measures have been introduced by the government. Which
See, one thing, they have to be objective assessment, of your financial situation.
Yes, Your Lordship.
So that is how they'll determine whether you're really in need of any assistance. So compassionate ground is like immediate assistance. You understand?
Yes,
So
Your
that you may not be
Yes.
you not be made destitute. That's the
Yes,
thing.
yes, Your
And so if they've done an objective assessment of your financial situation, then not a question of your entitlement. It's not necessary for you to be given that benefit.
Let them
You want to file a affidavit?
Yes.
Actually, you don't need to argue it. I don't think you have a case. Anyway, Mrs. Passar, MS Passar, pays for a 2 weeks time to file affidavit. Otherwise, let's pause next day. You bring authorities if you want.
Yes, sir.
Item number 5.
Yes.
Sure, I'm praying for some further time for rejoinder, my lord.
How many times after you joined us?
The first time, Lordship.
First time? Okay.
Last occasion affidavit was filed.
Mr. SD pays for allowed 2 weeks time for the joined affidavit.
I'm praying for 3 weeks, my lord, because petitions from Assam. Lordship.
Which part of Assam?
It was the petition is, my lord, for the death of the son.
There's a death son in Nepal?
In Nepal, Lordship.
Okay, 3 weeks time.
They're from Kokrajhar.
Lordship, I am appealing for number 246.
Yes, Mr. Naik.
May I please, Lordship?
Have you filed your affidavit?
Yes, Lordship, I am yes, already filed, Lordship.
Right. Then he wants to file a rejoinder. We'll give him 3 weeks time.
Yes, Lord. Yes.
Much obliged, Lordship.
Obliged, Lordship. Item number 6.
You've taken steps?
Yes, Lordship, we have taken steps.
Office note indicates that notice issued upon respondents number 4 and 5 were registered posted AD. However, the CM has not returned. So, counsel with petitioner to obtain status of service on the response 4 and 5 to file affidavit of service if necessary. Just after 2 weeks.
7.
Yes.
Please, Your Lordship, you said this matter has been delayed for
Yes.
of new village, and the order also has not been challenged or complained by any. It says here the case is that from a parent village, Your Lordship, there are 9 units. So for while one of the unit, the Smoking village, has been given a full-fledged separate village, they include our units into that village without our consent, Your
Your
Lordship.
village name is what?
Look, the whole village is Madan Lingdo, Your Lordship, and under Madan Lingdo there are 5 units: Kentoit, Dong Madan, Shat, Mauspung, Makuning, and Mautulup. When that Makuning was given a separate village, even our unit, Kentoit, has been given.
What's your Kentoit's name?
Dong Madan, Shat.
So you mean to say that when Maukling was given, included your Kentoit also?
Yes,
Totally?
Totally. So what happened? We have written to the
Where's the council?
Yes, then the chief of Hiring also has recommended a separate village worship. That's the only. Then this council has ordered to hold a referendum. But Your Lordship, since they have given an order dated 10/11/2020 to hold a referendum.
Let's see that where. Have you filed your affidavit? No. You're not filing.
Number 5.
Yes, yes. Yes, Mr. Kriyam.
Your Lordship, the order is the page 64, Your Lordship, and it's translated at page 66.
Is it 50 households or 30?
30 and 20 also from the other controlled, Your Lordship. So they want to be a separate village. So what happened, Your Lordship, on White Order dated...
So the referendum was held. What happened?
No, Your Lordship. 11 Feb 2021, another order that the council has come to keep the keep the referendum abeyance. Since 2021 till now, nothing has been.
Yes, Mr. Kinta. Can you hear us? Yes. Why you kept in abeyance? Mr. Sundram, you are praying for morning.
No.
We are from Madalungdo, the parent village.
What do you say, Madalungdo?
No, Your Lordship, we are a controlled of Madalungdo.
You want to remain Madalungdo?
Now, Your Lordship, what happened? Madalungdo also is not accepting us since 2013, but the benefits like BPL rice
So
not giving.
You don't want to go with what's this Maukling?
Yes,
Maukling.
Yes.
You don't want to go Maukling. You don't want to go state and Madalungdo skitty out also.
Yes, Your Lordship. But now the benefits we are cemetery and the BPL benefits.
I understand. So now you know, and then here no there.
Yes,
so you want to have own village now.
Either hold a referendum, Your Lordship, either we want.
Hold a referendum. That means that suppose he said, okay, fine, you steal Madalungdo, they don't want you any longer.
Whatever Your Lordship, the CM of Karim has submitted a report, detailed report, that unless until that the separate a new village has been created, that the law on the problem will not resolve in this for 11 years.
Yes, Mr. Kanta. Yes.
At least hold a referendum, Your Lordship. Whether
what referendum?
Whether a new village will
now
be...
you are set in your that you will remain in. You don't want to go to Mokning, right?
Yes, Your Lordship. But Madalungdo also is not accepting us now because we while giving a separate to Mokning.
So how will the problem be solved then?
That's what Your Lordship.
Because your very basis is that I don't belong to Mokning. I'm part of Madalungdo and I've been made
Madalungdo also is not. Madalungdo also.
And now they're not accepting anymore.
Madalungdo also is in 2013.
Yes, Mr. Kanta. Yes. What's he doing? Can you hear us? Can you hear us? Your microphone's off. Your microphone's off. What's he doing? Yes. Milord's matter on Tuesday. You come prepared. We'll dispose of on Tuesday. Due to some technical defect on part of the council respondents, this is matter on Tuesday. It's a fixed matter.
8. Item number 8.
Filed my affidavit today, my lord.
You filed it?
It's in the course of filing, lordship.
Yes.
We just received the documents. Some of them are in Garo, so we would tend to translate it. Some documents also not there, we have to get that copy.
Mr. S. Deb, response 1 to 3 submits that the affidavit filed the course of the day. You are Mr. S. Kariam on behalf of 4 and 5. Praise for further time for affidavit as the documents received are mostly in Garo language. Accordingly, 2 weeks further time is granted to the respondents 4 and 5. Yeah. 3 weeks? We have 3 weeks time. This is that after.
Much less.
9.
I'm filing it during the course of the day. I've served the copies already.
Mr. Evans submits that the after being filed in the course of the day, this after 2 weeks for the joint of any.
10. 10.
Please, Lordship. I shall pray for the 2 weeks time to file my counter, Lordship.
Why you only receive instructions?
Lordship, the instructions I received were incomplete, Lordship. But then I pray I meet the affidavit, but the petition by on material.
What about file? Only file Mr. H. Karanam. It was allowed further 2 weeks time to file affidavit. This thereafter is.
11.
Lordship, three weeks time may be allowed to file my rejoinder.
Yes, sir. Petitioner praise funds allowed, praise council praise funds allowed 3 weeks time by the rejoinder. This thereafter.
12.
Yes.
Right, please, Your Lordship. Your Lordship, notice has been served upon respondent number 3 and the same has been delivered. We've also filed our affidavit of
affidavit?
service.
Not, anyone appears for contemporary? No. Number 3 is whom?
Number 3 is the syndic welfare.
Is
The syndic welfare. Your Lordship, this is also office, but then actually, Your Lordship, here, what happened is that most of the communication is made by the respondent number 2. Respondent number 3 is just forwarding whatever communications have been made by the petitioner. District Syndic Welfare.
Okay. After the service has been filed, indicating the factum of service on the respondent number 3. However, none appears on their behalf today. What about affidavits? Filed?
Fine.
Yes, this is matter. You want to file rejoined or no?
No, Your Lordship.
This is matter after 2 weeks for further orders to enable the appearance for number 3. We'll hear it.
Okay, Your
For
Lordship.
hearing out. Let them give one more chance to appear.
And you're obliged.
13.
Lordship, the grievances of the petitioner has been addressed, so I may be allowed to withdraw the petition.
Yes, Mr. So submits that since the petition's grievance has been addressed, he no longer wishes to press the instant writ petition. When the matter stands closed on withdrawal. Okay.
14.
Lordship, in this matter, the three governments have to file their affidavits.
Please, Your Lordship, the affidavit of opposition is almost
Instructions are not complete.
No, Lordship, this is almost ready, Lordship. I'll file the.
When does the matter filed?
Lordship, this was 493.
Yes, Mr.
2022.
H. Please, how much time?
Lordship, 2 weeks time. I'll file by next week.
Lordship, for respondent second, for the MPSC, we have a former respondent, we won't be filing.
Yes, Mr. H. Please for the 1 week's time to file the affidavit stop. Ms. B. Karwanan, on behalf of respondent 7, submits that there are no affidavit forthcoming from their side. Just after 2 weeks.
Much obliged.
15.
My Lord,
Bolero cease.
Lordship, I am coming to that. As per the last status report, Lordship, we were in the lookout for the third owner of the vehicle. So, third owner has been traced. He's from Nalbari. So, a police team had gone there and raided the house. But it seems the owner, along with the vehicle, had fled away. Then thereafter, Section 41A was served through proper channel. And yesterday only, the third owner contacted the IO here. So he has undertaken to produce the vehicle by Saturday in the police station here. If it is not produced by Saturday, Monday the team again will go to Nalbari. That is my status.
You appearing for the owner?
Your Lordship, I will appear on behalf of respondent 1 and 2.
Who's 1 and 2?
Your Lordship, you.
Central government, Indian government.
Mr. R. Guru.
In fact, I also met the IO yesterday evening. He said the same thing.
He came here.
Yes, Mr. V. Bora, Mr. Guru, when he submit that the Mr. R. Guru submits that the active investigation is underway, and in fact, the third owner of the vehicle has
some time more can be given to the
to
investigation.
Produce the vehicle by Saturday.
Not so bad.
Feeling which the police will take
yes.
necessary action. Stop. Just a matter of 1 week.
2 weeks.
2 weeks is. Waiting for the keys to Bolero.
Yes. Giving enough time for the
I'm helping my friends.
investigation.
See that.
16.
We have filed this morning, Your Lordship.
Your Lordship, I have received copy of this morning, Your Lordship.
Yes, for which, what remains here? Why did we want the minutes of the DPC?
My lord, there was a direction to constitute the DPC, my lord. That was the interim order. So we couldn't conduct it. Now, my lordship, on the last occasion, we have made a submission that we have constituted a DPC.
Okay.
So we were supposed to bring on.
Yes, an affidavit has been filed by the respondent number
1, Your Lordship. Yeah.
one. Bring on record the minutes of the Department Promotion Committee held on 23/3/2023. The same is taken on board and made part of the it's the same. The address from the computer. So next parallel council petitioner.
I'll file a rejoinder, Your Lordship.
Do you want to do this?
Your Lordship, I have to take instruction, Your Lordship. Sorry.
Please will have to take instructions.
Yes.
On the affidavit. Just after 2 weeks.
Highly obliged.
17.
Lordship, I have taken steps for the respondent, and as per the online tracking, the notice has been served.
No. I mean served through SP.
Yeah,
Last time
you have
court
taken-
allowed that the service be effected to several police, since you see staying in the police reserve, correct?
Yes, Your Lordship. I have taken through SP, and copy has been served to the SP.
I'm sorry, what is your name?
RH Ellis.
RH Alice, correct? Yes, Mr. RH Alice, the council petitioner submits that as allowed by this code, notice on the one number 3. No, this is you. We asked you to serve it personally through SP Tura. See the order date 24/3. You have not done this.
It's written effective through effective service.
Allowed to effect service through Swan Police, West Carvales.
So it's not clearly written, Your Lordship. That's the or.
Right.
I may be allowed to take fresh steps.
Ms.
like
Alice submits that though, as per the postal delivery report, the respondent has been served. However, as per the order 24/3/2023, may be allowed to effect service. To effect service through civil police means effect to make it happen. You understand? Yeah.
So
effect service
I
to
may
the
be
civil
allowed to
police,
take test.
West Garo Hills, Tura within 1 week. Yes. Is that
Bless your Lordship.
Yes, after 2 weeks. Yes.
18.
Yes, Mr. Suna.
Quite some more time.
Why?
We have to receive the materials.
What's the matter about?
This is, Your Lordship, matter about maintenance order was passed by the District Council Court, directing me to pay 50% of my pensionary benefit. Being grieved, but the state respondent, they have passed this order at page number 24. Annexure 4. In compliance of the Honorable High Court order dated 30, the Governor of Meghalaya is pleased to order that 50% of the retirement pensionary benefit which is due to such and such to be paid to such and such. Your Lordship, this maintenance order we have already challenged. It is before the Honorable Justice, another bench. In revision petition, we have challenged that impugn order. But we are basically aggrieved with this order passed by the state. That there was no such order that directing the state to deduct, but they have passed this order. Direction was issued to me to pay, but no such direction was
But you're
issued.
paying 10,000 now.
Yes, I'm paying 10,000.
You file affidavit. Mr. Samsuna prays for around 2 weeks' time to file affidavit. Yes.
We are just complying the order because the original order was never challenged, and the subsequent order can hit the challenge in the subsequent order when they have not challenged.
Let them file affidavit.
Interim order, maybe.
Interim order pass unless it continues to the next date.
19.
Yes, Mr. Abraham.
I will be given some more time to file my counter, Your Lordship. 2 weeks time.
Any urgency?
No, ma'am.
2 weeks further time granted to the state respondents for the affidavit is thereafter.
Supplementary list, hearing, item 5.
Have you made a list?
If the case is taken up by next week,
I've made a list, at least make a list
Yes, I'll make
of
a
what
list.
applications were filed, what
Yes,
is MCA
yes.
18,
That is
17,
required, yes.
what substitution, what is, because
A small synopsis
the
is
matter is
required.
simple, but there's too many layers.
Yes, too many applications filed because of that.
Correct.
Yes,
File a list. We just want a list of this application was filed for this order was passed. Next application
yes.
filed for this was passed.
I'll prepare one synopsis and
Then even the whatever High Court orders were passed, remanding it back, this order was passed on this date. Just a small list.
A small list.
It's just a brief fact. We don't want anything else. No, no arguments.
No.
Only what was filed and what orders were passed.
Yes. Well, after a week or so, I'll just prepare the synopsis.
Actually, we wanted to anyway. Ms. M.F. Qureshi submits that as the list could not be prepared today. The list of dates. The list of dates, yeah, with the list of events could not be prepared today. Prayers have been allowed further 1 week's time.
Yes.
Yes. Prayer allowed. You just bring it, or you make your one also and you bring it.
Yes.
After 1 week. Yes.
Main list, hearing 22.
My lord, the last order dated 30th of March. My lord,
Yes, what instructions you received?
Your Lordship, we have been instructed, learned DSGI, Dr. Mazda has been instructed to appear on behalf of respondent 2 to 5 as well, Your Lordship. And as per the instructions, the learned DSGI would want to be physically
He's
present.
where's the director?
Your Lordship, senior would like to be physically
No,
present,
this is
Your Lordship.
see look the last order. Today also the council respondent submits his inability to place instruction over his court. This will matter. Last portion is given to respondent to place instruction. Somebody permit shall appear personally. Okay, we'll then fix a date for personal appearance of the director. See, you haven't come with instructions today.
Your Lordship,
Let him appear on Tuesday.
Tuesday,
at
my lord.
10:30.
Tuesday, 10:30, my lord.
Your Lordship, we're also filing an affidavit on account of the prayer number 3 that has been filed in the writ.
What prayer number 3? Doesn't matter. The thing is that see, the order is very clear. You come with instructions today or you appear.
Your Lordship, if one last chance is given as
You can't change counsel and expect that you'll get the the concession from the court that.
Your Lordship, let this matter come up on Tuesday, and that is instructed by my senior Your Lordship.
Okay, MS S. Rumthau, Learned Counsel Vice Dr. N. Mozikali just submits that the matter has been entrusted to her senior, but due to personal difficulty, is not supposed to appear today. Stop. Next part is noted that by order 33/2023, it has been recorded that the respondents were to place instructions by today, failing which the director was to appear personally on the date to be fixed by this court. However, considering the personal difficulty and interest of justice, this is matter on Tuesday. Yes.
Director is appearing, my lord, because it's the last chance.
No, it doesn't matter. We'll see. We'll make him appear. There's no instruction coming.
34.
If this matter can come up after a week.
Due to absence of not DGSI, this is matter after 1 week.
Hello, Mr.
Yes. Any mention of legal? What's happened to your case?
It's on the way.
Wait a minute. On the way meaning?
It's been filed. Everything's ready. My colleague has gone to request them to send it down.
Okay, inform the court when it's done.
Highly pleased. Highly pleased.